Good morning. The Appellate Division's special session is now beginning. Welcome to the Appellate Division, First Department. This is a special session with regard to the case of People versus Patrick Johnson. If you would note your appearances, please.
For Mr. Johnson, Marika Meese by the Center for Appellate Litigation.
And the time you're requesting?
I'm requesting 10 minutes, or actually 8 and 2, if that's possible.
I'll give you 6 and 2.
Thank you.
For the People?
Michael Yetter for the People. The request is for 6 minutes, please.
6 and 2 and 6. All right. Ms. Meese, is it?
Yes, correct.
Get that right. If you would proceed.
Thank you. Good morning, Your Honors. May it please the court. On this case, the court previously remanded, having found that counsel had misadvised Mr. Johnson about the consequences of the immigration. And at a hearing on the prejudice prong, Mr. Johnson proved by a preponderance of the evidence that had he been properly advised, he would have rejected the plea. The hearing court improperly found that Mr. Johnson knew about the true immigration consequences and just didn't care.
Wasn't the court's finding, counsel, really based in large part on credibility, which is something we normally don't interfere with?
It was in part, Your Honor, but there are reasons to disagree with the court's credibility finding because, for example, the court made findings that were either contradicted or unsupported by the evidence. For one example, he found that Mr. Johnson was not able or had overstated the risk to him had he returned to Jamaica. But in fact, there was evidence in the record that his brother had been murdered and that his particular circumstances, having previously been a member of one of the political parties, made him at particular risk. Would he be deported at the time? And also the court it wasn't that the court failed to credit certain facts. For example, on the issue of whether Mr. Johnson was able to leave Kingston and move to Sav Lamar in the country, the court found that he found safe haven there. But in fact, Mr. Johnson testified that it was equally dangerous and violent there and that there were funerals almost every Sunday. So there was ample evidence in the record that the court just either ignored or didn't credit. And therefore, it is open for this court to readdress those credibility findings.
Ms. Meese, this is Justice Moulton. Isn't the standard actually reasonable probability rather than preponderance of the evidence? And isn't that a higher standard than preponderance of the evidence?
I think it's both. I mean, Mr. Johnson's burden under the 440 statute is preponderance of the evidence. Under specific cases involving a plea, such as Mr. Johnson's, there is an articulation of a reasonable probability standard, but I think they are both applicable here. And no case has spelled out that the preponderance evidence doesn't apply. In fact, there are numerous cases suggesting that in a plea context like this, the preponderance of the evidence standard does still apply.
Well, if we were looking at it under a reasonable probability standard, that he wouldn't have pled guilty if he were given the proper advice, what then with regard to the judge's determination?
I still submit that the court got it wrong, that there was ample evidence that Mr. Johnson actually did care about immigration. He reasonably focused on the criminal case first because every lawyer, including the immigration lawyer he briefly had representing him, told him that the criminal case came first and that he would then have a fighting chance in immigration. And so that was his understanding. No court, form, or lawyer ever told him otherwise. And many of the things that the hearing court focused on either came before or after the plea. For example, the court focused in large part on this notice of immigration consequences form that Mr. Johnson received at his arraignment on the first indictment that was later dismissed. And that generic form that Mr. Johnson may have lost and maybe didn't remember exactly what his lawyer told him about wasn't controlling. In fact, the form itself says you should speak to your lawyer about your own particular unique circumstances. And that's exactly what Mr. Johnson did. And he remembered the advice that was given to him.
Excuse me, this is Justice Gesmer. Isn't the significance of his of the issue with the notice of immigration consequences really that he knew that he'd lost it, but didn't do anything to find out what it said and to look at it again. If he'd really been concerned about immigration consequences, then losing a piece of paper that would be so probative would have been something he would have been worried about and asked for another copy of.
And my suggestion is that the form wasn't so probative. It's just a generic form that every person gets. And what the form actually says is talk to your lawyer about your individual immigration consequences. And that's what really matters. And so he did that precisely. And there's no court that has ever held that in the prejudice context like this, notice of immigration consequences form could preclude a finding of prejudice. In the Peque context, the Court of Appeals has held that it's relevant to preservation, but Mr. Johnson's claim was a misadvice, a McDonald claim. And so whether he lost the form, because of understandable circumstances of there having been a fight in corrections when he was incarcerated, he did speak to his lawyer repeatedly and ask for assurances about what would happen. And his lawyer repeatedly told him that he would go to immigration, he would be maybe in deportation proceedings, but that he had a fighting chance. And that's the advice on which he relied.
Counsel, Justice Kennedy here. I'd like to go back on the claim regarding the violence. Was there any evidence that he continued to face political violence in 2016 and 2017?
Yes, Your Honor, because he testified that with news from Jamaica at the time of his plea, he was aware that that kind of violence continued, and his sister corroborated him on that fact. So although there had been some testimony about the upheaval when Cook was extradited to the United States, the violence that he feared and talked about wasn't isolated to that incident. And in any event, under the prejudice factors, it doesn't have to be that they are so decidedly in his favor. I think the court and even the people agreed that most of those factors, like his incentive to remain here and his connections to his family, his better employment, his housing, were better here. The hearing court found that such is the case for every immigrant and sort of discounted those factors. But if the burden is preponderance, then even if it's just slightly better, that meets that standard. And in terms of the other two prejudice factors that the court looked at, the strength of the case and the possible sentencing exposure, the court ignored existing case law that says that the strength of the case not being tested is relevant and that factor alone is not controlling, especially where the other factors weighed in his favor.
Thank you. And in terms we'll end it there. You have 2 minutes rebuttal.
Thank you so much. Let me mute.
Thank you. Mr. Yetter.
Good morning, Your Honors. Michael Yetter for the people. The hearing court's credibility determination in this case that defendants claim that he was prejudiced by his attorney, Mr. Brenner's on the record misadvice at the plea proceeding was not credible. And that finding, which was based largely on and almost entirely on the judge's determination of the defendant's credibility, is entitled to great deference from the court. The judge focused on two main factors. One was that the defendant received accurate information about immigration consequences, both from the NOIC that he was served with and from Justice Sonberg before he pled guilty, and yet pled guilty anyway. And then his testimony and the contemporaneous record showed that he was focused almost entirely on minimizing his sentence exposure and did not evince an interest in his immigration consequences. And that was corroborated both by the contemporaneous evidence and by his hearing testimony.
Counsel,
for those two,
Counsel, this is Justice Casimir. With Counsel, Ms. Meese argued that we should not consider Mr. Johnson's later guilty plea in the Bronx cases, even though it's undisputed there that he was advised that what he pled to would result in mandatory deportation. What is your view on that?
My view is that Justice Stetzinger correctly considered those pleas on the question of his credibility, meaning his testimony that he would not have pled guilty in this case had he been advised that his plea would result in mandatory deportation, as opposed to what he was actually advised on the record, which was that it was most likely. So it's a credibility question. We do not dispute that Martinez and this court's other cases say you cannot consider post-plea events on the merits of a prejudice claim. But this Justice Stetzinger was quite clear in his decision that this was about credibility. And just to point out, the Bronx pleas were in the works, and defendants certainly knew about them at the time he pled guilty in this case. His hearing testimony was that he understood that this was part of a package deal. And now we realize, of course, these were separate pleas because they occurred in separate counties, but defendant knew about these at the time. So I think the judge was correct to consider that on the question of defendant's credibility of his ultimate claim about what he would have done in this case had Brenner's on the record advice been accurate.
What about the factual basis, the factual statements with regard to Jamaica and the crime there and the danger there, and counsel's argument with regard to whether we should be looking at this from a preponderance of the evidence basis, or whether or not there's reasonable probability?
Well, on the factual point, I think globally the judge was concerned about defendant's credibility. He at the hearing, him and his sister both testified in general about violence in Jamaica that they may have read in the news. But his hearing testimony also established that when he left Kingston and went to Savannah Lamar, he had a year or more where he was able to work as a fisherman, make income, and live peacefully. It seems from the hearing that the violence in the area stemmed from the extradition of the drug dealer Christopher Koch, but it's not clear at all from their testimony that political violence continued and was extant in 2016 and 2017 when the defendant entered this plea. As to the standard, I think the preponderance would be, if you're talking about a 440 proceeding where the defendant has to prove the essential facts by preponderance of the evidence, I don't know that it matters that much. Reasonable probability, I don't think, is a higher standard. I think in Strickland, they say a reasonable probability is a probability sufficient to undermine confidence in the outcome. And they do talk about that in Strickland, but I don't think it matters here. I think ultimately the judge did not credit the defendant's claim, and there's ample record basis to support those findings as detailed in the court. If there's no other questions, I would ask the court to affirm.
We're back to you, Ms. Meese.
Yes, thank you, Your Honor. Just touching briefly on the issue of whether the Bronx cases should have been considered at all. The court did try to kind of make this credibility exception, but I don't think that is consistent with prior case law from this court. And Gaston and Martinez, it was specifically in the context really of credibility of the prejudice determination, whether things that happened afterward were relevant to show that the defendant was interested in immigration. And so to hear what happened at the Bronx plea and what, if any, advice he got there, really is the same. It's the same kind of factor that, precedent from this court says cannot be considered because the prejudice inquiry is focused on the time of the plea. In terms of the Bronx pleas as well, and whether there was a package deal, Mr. Johnson may have said something along those lines, but it's clear from Mr. Brenner's statement and from other evidence that the Bronx pleas were totally independent. There was no evidence that had Mr. Johnson refused the plea here and gone to trial, that those Bronx pleas would have been withdrawn. They were made because of the weaknesses in the Bronx case. They were made before, they would have been made after. So to call it a package deal because Mr. Johnson, who's not familiar with the law and doesn't understand the importance of that term, agreed to that on a cross-examination question, I don't think fairly assesses how those Bronx cases factored in. And in fact, counsel said on the record, Mr. Brenner, at several points that there wasn't a global disposition, that these were separate pleas, and that's clear from the record. So the hearing court agreed that Mr. Johnson would not have faced more time had he gone to trial. This was a recommendation to more than the minimum. Mr. Johnson was a first offender. And so in analyzing that factor, I think the court overstated the importance of the Bronx pleas, which really were not controlling. And anything else? If your honors have no further questions, I think I will rely on the record. But if I could just circle back in terms of the Mr. Johnson's credibility, I do think that there were numerous factors. It wasn't just on the violence, but in addition to Mr. Johnson saying that he was able to find work in South Lamar, he stated that there were funerals almost every weekend and that the violence was there. That was not exclusive to the period of extradition. And he also testified about having news from Jamaica at the time of his plea, which is particularly relevant too. So for all of those reasons, I think that Mr. Johnson did establish that he would not have pled guilty if properly advised of the true immigration consequences, that he always understood he had a fighting chance in immigration, when in fact he had zero chance of relief and deportation was mandatory. And the court's other statements at the time of the plea, like the Peke warning, this is not a Padilla claim, so it doesn't matter whether the court gave an advisal. That doesn't undercut the misadvice that he was given, and nothing the court said did so.
Thank you.
Thank you.
Thank you both. This concludes the Appellate Division special session.